Board is now in session. With John K. Startle, Judge presiding. All persons having business before the board shall come here, give attention, and will be heard. In God save the United States of America, the state of Florida, and this honorable court.
Good morning. I'm Judge John Stargell. To my right, I have Judge Petra Brownlee, and to my left here is Judge Roger Gannum. We have only one case on our docket this morning, Clausen Trust et al. Versus Crowther Roofing and Sheet Metal. It's 23-2609. So who will be arguing today? Will that be Mr. Brannick and Mr. Webster? Okay. All right, we'll just ask everybody in the audience, if you have your phone, please make sure that they're on silent. And would you like to reserve any rebuttal time?
Yes, Your Honor, 5 minutes if I may.
Okay. You got that? And you're recognized again?
Good morning, Your Honors. May it please the court, I'm Steve Brannick of Brannick, Berman & Sider, representing the Clausens and their trust. While installing a new roof, Crowther first flooded the contents of the Clausens' home, and if that weren't bad enough, set fire to it, almost burned it down, causing millions of dollars of damages. But in a series of rulings on summary judgment, the trial court took virtually all of the damages that Clausen suffered away. What I'd like to do today is focus on the 2 points that I think are dispositive of the entire case. The exculpatory clause, whether that's enforceable or not, and then the independent tort doctrine. So let me start with the exculpatory clause. Crowther's extreme position is that the contract that Clausen signed says that Crowther can negligently flood the house, it can burn down the house, and it's not liable for anything but providing the new roof that it had promised in the contract. Now, Florida law says that that kind of contract is enforceable, but it sets a very high bar. The Florida Supreme Court reiterated in its Sanislo case that both parties have cited here that Florida public policy disfavors those sorts of exculpatory clauses for the simple reason is that it shifts liability from the party that's got the ability to conduct themselves with due care, and it shifts the liability over to the party that really has no control over the situation. So you have to make your intention to have such a disclaimer extremely clear. As Judge Kennedy said when he was sitting on the second DCA, you must use clear and unequivocal language totally without hints of deceptive, come on, or inconsistent clauses. That's the Murphy case that we've cited in our brief. Well, this clause doesn't come close.
Is this kind of a case-by-case, we'll know it when we see it situation? If it's 10 font and set out separate, then it meets the standard, but if it's 6 font and hidden everywhere else?
Well, I mean, I think each case, stands and falls on its own. You have to look at the language of the paper, at the language of the clause. But there are a number of reasons why we think here that clause doesn't pass muster under Florida law. Let me start first with the big picture. We've got lots of different interpretations of this clause. Crowther's interpretation of the clause is that all they have to do is provide a new roof, and they're not responsible for any damages whatsoever, even if they burn the house down. Now, we say what the clause is designed, what any reasonable consumer would think looking at the clause is that Crowther is limiting the sorts of damages that would be suffered from a leaky roof after it completed the job. So yeah, Crowther's going to replace the roof, but we're not going to be responsible for damages caused by the leaky roof. Now, the trial court came up with a completely different interpretation of the contract. She decided that anything touched by the flames or the water would be, in fact, recoverable regardless of where it was. So the trial judge rejected their most extreme position. But that's 3 positions right there. And in fact, Crowther itself has taken at least three different positions during the course of this case. First, we have its extreme position that all it has to do is provide a roof. Then in its brief, in the front of its brief, it says, well, this is really nothing more than just a damage limitation on consequential and incidental damages. But then later in their brief, they say, no, we're not responsible for anything but the roof. And then finally, you've got the position that Crowther took after the first incident happened, the water incident happened. They took responsibility for the water damage and fixed it. Well, if their contract meant what it said, they wouldn't have had any responsibility. So the fact that we have so many different interpretations of this language, looking at the big picture, is a
Can we
huge
step into
indicator
that
that
a
we
little
have
bit
ambiguity.
further? If so, because they took on or appear to take on the duty to clean up from the first mess, is it your position that they then had to do whatever the homeowner asked them to do
Yeah.
to fill it?
I'm not suggesting this is a waiver. What I'm just suggesting is that the parties have looked at this language and come up with a number of different interpretations, including Crowther itself. That's the only point I'm making, is that you can read this contract in a lot of different ways, and that's a huge indicator of ambiguity.
But what is their responsibility once they started cleaning up? Is that, at that point, do they have an obligation to make sure that the moisture is out? Or were they just doing that out of goodwill?
I think they have a responsibility to fix all of the damages that they cause. That would mean all of the water damage to all of the structural parts of the house, the personal property, the mold and the mildew that happened as a result of that, and the same with the fire. You've got the fire, you've got the smoke, the fumes, the heat, the damage caused by the fire department. They're responsible for all of that. That's certainly our position.
And this is because of their negligence in not covering the roof before a storm, unlike an active guy,
Right.
like a hurricane.
Yeah, and they admitted that in their opening statement. They said, yeah, this was our fault. We should have put that tarp down.
Mr. Brannick, is there a fair reading of the text of this exculpatory clause? It's paragraph 8, I guess, in the terms and conditions. Is there a fair reading of the text that gives effect to every word and still allows for the damages that you're seeking? Talking about the smoke, the soot, the water from the fire hoses, from the fire, and then also the mold and moisture damage from the leak. In other words, is there a way that we can not throw the text out, in other words, enforce it, but it would still give you a path to the damages that you're seeking?
Well, I think what Florida law tells us is that if the clause is ambiguous, they can't disclaim liability for their negligence. And so I think the clause just goes out the window. I think at most, perhaps you could interpret this clause to be a more traditional product sort of clause, which is, we'll give you the roof, but we're not going to be responsible if the roof leaks. But of course, this has nothing to do with the leaky roof. This is a case about the damages they suffered while they were on the property. I think, kind of going back to the big picture again, the point I would make is that if you want to disclaim the damages that they suggest they're disclaiming here, it doesn't take that very long paragraph to do that. I think all you would have to say is something like this: our liability is limited to providing a watertight roof, and we are not responsible for any damage to your property we caused while working on the site. And if they wanted to be even more upfront, they could say, regardless of whether we were negligent or not. It would be very easy to say this clearly. I've looked at this clause now for years. There is no way you can look at that clause and not struggle with its meaning. So the question is, did they put their cards on the table as Florida law requires? And I think the answer is no. And I like to start with kind of the common sense. I mean, look at the font. I mean, there's fine print, and then there is fine print. This terms and conditions is just about impossible to read. Now, they'll say, oh, we send it as a PDF, and so you could blow it up. Well, I've tried blowing it up. I'm sure your honors have looked at it in the record. Blow that up as much as you want. It is still very hard to read. Now, I'm not suggesting that that's dispositive. I'm not asking this court to create a law about font size or anything. I'm just suggesting this is one of the elements we look at in terms of, did they put their cards on the table? Clearly they didn't. Now let's look at some of the specific language in this exculpatory clause. In paragraph 2 of those tiny terms and conditions, they agree to perform their services in a workmanlike manner. But then later on in paragraph 8, they say that all claims, that you can't bring any claims, and of course that would include claims caused by not performing your services in a workmanlike manner. Florida law is clear, and this is the Murphy case that I talked about that Judge Kennedy wrote when he was on the second DCA. You can't write a contract that gives up front and then takes away in the back. In other words, if you have a contract that sets a standard of performance, you can't then put in an enforceable disclaimer of liability. So that's the Murphy case, the Blakely case, the Obsessions case, the Michelle case, the Ivy case that we've cited in our brief. All of those are cases that have contracts that have a performance standard in them. And then the party, despite that performance standard, tried to disclaim liability for any damages caused.
Let me ask you about this workmanlike manner standard. Your opponent says that really only refers to the completed product. In other words, I look at the contract when it's done and ask, was it done in a workmanlike manner? Your position, I think, is that also includes some duty of care during the performance. For example, not to set the house on fire or something like that. But it's hard to find a case that really articulates what that contractual duty of care is during performance. Because I think your opponent is right to some extent, and that most of the cases just talk about it sort of after the fact. So what is involved in that workmanlike manner duty in terms of during the performance?
Well, I mean, the use of the word manner implies an activity. So to me, if you're going to conduct a contract in a workmanlike manner, you're talking about more than just the completed project. You're talking about how you work on the job. So, are you leaving a mess every night? Are you putting the tarp on the roof at night? Are you setting the fire watch so that the thing doesn't burn down? There could be differences of opinion about how far that duty extends. And there were differences of opinion in the trial court, but the jury resolved those differences of opinion against them, and they haven't appealed that. So it's clear that they didn't meet that contractual responsibility here. But I don't think you can look at, the contract has to be completed in a workmanlike manner and to just restrict that to whether the roof was okay or not. Workmanlike manner is, implies the process of doing the job. So I think it's that simple. So we've got the problem of the contract giving and then taking away. Secondly, you've got the problem, you got to look at the language in context. If you look at the way, this clause overall, I think it would suggest to a reader that what they are trying to limit is the damages that would be caused by a leaky roof after they're done with the job. We're going to be responsible to make sure you have a good roof. If the roof doesn't work, we'll fix it, but we're not going to be responsible for damages from a leaky roof. Now they disagree, but they let's look at their best sentence in that clause. It says the contract excludes claims for damages that may occur during the re-roofing application. All by itself, that sounds pretty good for them, but put it in context. What is the only example that they then provide? They say, for example, structural damages such as cracking of ceilings or walls during re-roofing. That is the normal sort of damages that you might expect from folks working on the roof. So that would suggest to the reader, yeah, we're not going to be responsible if we're standing on your roof and your walls aren't strong enough to hold us up. But that's very different from saying we're not going to be responsible if we flood your house, or we're not going to be responsible if we burn it down. And there are a number of cases that talk about this concept, about looking at it in context and deciding, what would the reader be thinking about? The UCF athletics case is a really good example of that. It's another case that has a disclaimer that relates to all claims. But the court looked at it and said that, when you look at the entire clause in context, it would suggest this was about a football player signing up at the university. And the court said, well, I think a person would expect you're probably waiving all claims that would be normally incidental to playing football. People get hurt playing football. And so it's understood in this contract that you can't sue for that. But they said, we're not going to read it so broadly that would protect the university against negligent supervision of the players during practice. The parties wouldn't understand all claims to be something that goes beyond the normal incidents of a
Counsel, I know that you've taken issue in your briefing with how the trial court defined consequential damages as opposed to direct damages. Say in a different world where your client was content with the outcome and that trial judge had correctly, in your mind, ruled what is an example of consequential damages in this case, and what is an example of direct damages in this case, right? Say it aligned. What then would that trial judge, in your mind, procedurally have needed to do to effectuate that and take that to trial? Because I'm interested in the portion where now there's a subsequent hearing on this notion of damages. Maybe it's an extension of the summary judgment, yet the trial judge is taking evidence on that point. Perhaps it's a motion in limine. Maybe some evidentiary submissions are proper. I understand your point to be, in addition to what I just stated, that, well, you can't resolve issues of fact, right? We've had that competing expert testimony. But what in your mind, from a procedural standpoint, needed to happen, even if the trial court were going to rule in your favor on the idea of what was a proper definition of consequential damages in this case? How does the trial judge resolve that? Is that proper on summary judgment if there were no disputed issues of fact?
If there were no disputed issues of fact, yes, I think it would be proper on summary judgment. Our
But
point is
isn't
that
the interpretation of that exculpatory clause a question of law for the court to resolve before trial?
absolutely.
Tell me about this. How do I
Yeah.
reconcile those things?
Well, I have never seen a case that goes from summary judgment to an evidentiary hearing to a summary judgment based on an evidentiary hearing. That's a very strange procedure. I think what I would say that there are definitely disputed issues of fact here. We had expert testimony during this hearing about what is fire. Is fire just a flame? Is fire include all the products of combustion, such as smoke and fumes and embers and ash and everything else? The experts thought about that. So you have a disputed issue of fact. I'm not sure exactly how you would do the jury verdict form, but there had to be questions that should have been sent to the jury, and then maybe based on the jury's answers to questions like what is the fire in this case, then maybe the judge could either on directed verdict or in a separate legal ruling, decide how the language of the clause, assuming it's enforceable, and of course we think it's not, how it would apply to those facts as decided by the jury. But I don't think you can just have an evidentiary hearing with disputed facts and then come up with a ruling like the trial judge did. I see that I'm intruding into my rebuttal time, so if I may, I'll reserve the rest.
Mr. Webster, you recognize.
May it please the court. Judge Brownlee, I'd like to start by attempting to respond to your question regarding the trial court's ruling on consequential versus direct damages. The cases that the Claussens cite are cases involving the extent and or existence of damages. Those are clearly jury questions. Equally clearly, the issue of whether a particular type of damage falls into the category of direct or consequential for purposes of the exculpatory clause is a question of law. And the case the trial judge relied on is a case the Claussens cite in their briefing, Keystone Airport Authority versus Pipeline Contractors, 2019 first DCA case. In that case, the court affirmed a partial summary judgment that determined certain damages were consequential rather than direct, and therefore waived as a matter of law by the exculpatory clause. The same is true of Tri-Lady Marine versus Bishop Mechanical Services.
But counsel, in this case, so we have on the one hand, the trial court making the determination, which my understanding of your argument is that the trial court makes that determination as a matter of law as to how we define consequential damages and how we define direct damages. Right. But then, and I'll have a follow-up question to this because I don't understand the procedure in this case. So once you proceed somehow to an evidentiary hearing, is there not competing expert testimony about what is caused by fire, what is caused by flood?
The trial judge said, and I think this is clearly correct, experts' evaluations of what kinds of damages these are irrelevant. Lay people's evaluations are irrelevant because this is a question of law. The trial judge said that she wasn't going to determine whether the damages were legitimate. All she wanted to do was know what types of damages were being claimed. So
Why is she having an evidentiary hearing on that?
the evidentiary hearing was totally unnecessary.
Because couldn't she have just made that decision at the initial
Sure.
summary judgment?
Sure, what she could have done is what the trial judges did in Keystone and in Tri-Lady Marine. Just ask the Clausen's lawyer to identify the types of damages that were being sought. So the evidentiary hearing was unnecessary, but it was clearly harmless. All she was trying to do was figure out what the types of damages were they were claiming. And clearly, once she had that information, she goes to the exculpatory clause and decides whether they fit or not. If they fit, they're barred. If they don't fit, they get to go to the jury. And that's exactly what happened here. So the quote evidentiary hearing, utterly unnecessary.
Was that a sua sponte decision?
The decision to hold an evidentiary hearing, yes, it was, Your Honor.
So can you explain to me why this line of demarcation that was made for the consequential versus direct damages? Because I'll be candid with you, I think it's persuasive. The opposing side's definition of consequential damages that's set forth in the briefing. Can you tell me why this is correct? Why aren't these direct damages of what happened? So if it's a flood, these are the damages of the flood. If there's a fire, yeah, there's smoke. All of this is a direct damage of fire, not something consequential or incidental.
Sure, I'll
let
be
you
happy
answer.
to address that.
Thank you.
The trial judge said that she was relying on the Keystone decision for the definitions. She said she was also relying on some of the cases cited in Keystone, including Erling versus Helms. Erling versus Helms is the case involving the termite exterminator who concluded there were no termites, and it turned out there were, and the house essentially had to be torn down and rebuilt. All of that was determined to be consequential damages. The cost of the contract are the direct damages. And we've cited numerous cases for that proposition. So beyond that, the general rule is that direct damages are limited to the benefit of your bargain.
Isn't the difference in that case, it's the termites that did the damage. It's the very thing that they were looking at to eliminate and saying, we're going to do what we can to get rid of those. But clearly in the contract, in that case, they said the homeowner knew. I mean, you go to other cases like the UCF case, we talk about the Porky's Gym case where another patron attacks them. I mean, why is this not more aligned with those cases where there's some other activity that's happened that caused this damage?
Thank you for the opportunity to get back to talking about the waiver clause. The issue, we need to be clear about what the issue is here on the ambiguity argument. The issue is whether the waiver clause, paragraph 8 of the contract of the terms and conditions, is ambiguous. The issue isn't whether you can go pull things out of other parts of the contract to create ambiguity. Every single case that's cited by either side on this appeal, including the Murphy case that the Clausens rely so heavily on, involves deciding whether the exculpatory clause is ambiguous. And in all of those cases, the ambiguity was in one part of the exculpatory clause, it said, we're going to do this. We're going to try and exercise our best care. And in another part of that same clause, it said, but we're not going to be liable for anything. We don't have that here. The only confusion they can create is by going to a completely different paragraph of the terms and conditions.
But wouldn't we read the contract as a whole? We don't read, so is your argument to us to read the exculpatory clause in a vacuum?
My argument to you is that every single case that either side has cited on ambiguities in the exculpatory clauses involves examination of the exculpatory clause in its entirety.
Counsel, assuming that that's the case, as I read Sanislow, that the exculpatory clause has to be clear and unequivocal and unambiguous. So that's two, maybe three different concepts. But can you tell me what is your reading of the text of just the exculpatory clause that says that you are not responsible for setting the house on fire?
Sure, I'll be happy to do that. The issue is, number one, whether it's a question, an issue of law, those kinds of damages would be direct or consequential. And once you decide that, then you look to paragraph 8 to decide whether there's any ambiguity. You know, they want to talk about ambiguities by going to the end of paragraph 8. The title of paragraph 8 is Disclaimer of Incidental and Consequential Damages. And the very first sentence says, owner expressly waives any and all claims for special incidental or consequential damages that it may have against Crowther without limitation. I mean, how could that be any more clear? It's certainly at least as clear as the exculpatory clauses in Elleluth, Merlion, and in fact in Sanislow.
But it's the second sentence where I think your briefing makes the claim that, or gives a reading that says the owner specifically excludes, waives, and relinquishes any claims for, and then you highlight damages that may occur during the re-roofing application. Now, as I understand your argument, you're taking the position that if any damages occur while we're installing the roof, they're not our responsibility. Our only responsibility is to deliver a complete roof at the end of the day. And I'm wondering if you have cut too much out of that second sentence to get to that point. Because when I try to read it as you've presented it in the brief, it seems like it leaves a lot out.
Okay, so you have to read the entire paragraph giving effect to all of the words. The very first sentence simply could not be any clearer. And then it says, including without limitation, and then it proceeds to give examples. That to the extent damages are consequential, they're waived.
So let me ask this way, because it sounds now like what you're saying is that if with the fire, if the smoke and soot and damage from the fire hose water, if those damages were direct, they would not be excluded by this exculpatory clause.
I think that's right.
Okay.
And we cited several cases in our brief for the proposition that soot, water damage, and that sort of thing are consequential damages. They're not direct damages from the breach of contract. And so there's nothing inconsistent when you read paragraph 8 in its entirety. And to get to where they want to get, you have to just read the first sentence out completely.
Maybe this gets over into the independent tort issue, but you just said that those damages are consequential from the breach of contract. So what is the breach? Is there no duty to install a roof without setting the house on fire? In other words, would the breach only be not delivering a completed roof? Or can you breach this contract by just being really negligent, in how you treat the property while you're installing the roof?
If they had pleaded and proved a tort that was separate and independent from their breach of contract claim on the water intrusion claim, then they would be able to recover. But not only did they not plead or prove a separate and independent tort, and they don't point to anything in their briefing that happened in the trial court that suggests they did try to plead or prove an independent tort. But not only did they do that, but then they chose not to submit the breach of contract claim for water intrusion to the jury.
You take the position that the express term of the contract to proceed in a workmanlike manner does not create any duty to put the roof on in any particular way. It's just the completed product. But then I think they have a right to plead in the alternative that it's a breach of the contract or it's a breach of a common law duty, and then make the decision before it goes to the jury, we're going to go with tort. So what I can't reconcile is, on the one hand, it seems like you're arguing there is no contractual duty that was breached by letting the water into the house. But then you say they haven't proved a separate tort, citing the independent tort doctrine. It seems like you want it both ways.
Well, Your Honor, the law is perfectly clear, perfectly clear, that to establish a tort in a contractual case like this, you have to establish that it's truly independent of the breach of contract.
So was it a breach of contract for Crowther to not secure the opening in the roof that let the rain in? Was that a breach of the contract?
Crowther admitted that it was, but they chose not to pursue that. That wasn't our choice, it was theirs. They chose to proceed on a tort claim only, on the water damage claim, even though they knew that Crowther's position was that the independent tort doctrine foreclosed that claim. We can't be held responsible for their election on how to proceed to the jury. If they had proceeded on the contract claim on that count, we wouldn't be here arguing about this.
So we might be here arguing about the things that happened before that, but we wouldn't be arguing about that.
Exactly. We might be arguing, and let me just say, I know that all of this sort of sticks in the craw in terms of fundamental fairness concepts. I get that. But we're talking about contract principles here. And
Well, I'm glad you got back to that, because I didn't want to interrupt that line of thought. But when you said we only have to look at this one provision, and your argument is that it's a complete waiver, explain again why we shouldn't look at the provisions that put a limitation of liability at the amount of the insurance and other things that tend to all point to that this wasn't or might not have been clearly a waiver to the extent that you're arguing.
those provisions have nothing to do with whether the paragraph 8 is ambiguous. It's as simple as that.
But can't you imagine a world where another provision of a contract would be relevant to paragraph 8? I mean, what if there was one paragraph about general liability and then one paragraph about direct damages and then this exculpatory provision about consequential? I mean, wouldn't they bear on one another? What if there's a definition section that actually defines consequential damages? Wouldn't that then bear on paragraph 8?
Sure it would. But that's not what we have.
I think they're saying that there's another provision of the contract that would render paragraph 8 ambiguous.
But there's not a single case they can cite to you that looks outside of the the actual clause that's involved to determine whether it's ambiguous. There's not one single case. In the time I have left, I would like to talk about the font size issue. That's simply a red herring for two reasons. First of all, because they have not argued either below or here unconscionability. That's the first reason. But the second reason is because Mr. Clausen, a sophisticated businessman, actually read paragraph 8. I mean, he testified he read paragraph 8, as well as the rest of the contract. So whether it's small, large, utterly irrelevant. In fact, in Elaloof, the court said, the fact the language releasing the school board from any injury or claim resulting from athletic participation was a smaller font size than the portion of the release addressing inherent dangers does not somehow change its meaning or render the release unclear or ambiguous.
Mr. Webster, if he read the contract and read it one way, and you're reading it another way, and we've got 3 or 4 different ideas of what it means, how do we hold that against him because he did due diligence and read it? If it's not clear, it's not clear. If it's not clear and ambiguous, why shouldn't we reverse?
Sure. Your Honor, he was the president and CEO for more than 20 years of a manufacturing corporation that employed more than 1,400 people with 11 factories. And he was the co-beneficial owner of a multi-million-dollar.
So he's better than even three judges, 10 attorneys that have looked at it and still haven't come to a conclusion of what it means?
Your Honor, again, to me, it's pretty straightforward. The first sentence of paragraph 8 says, owner expressly waives any and all claims for special, incidental, or consequential damages that it may have against Crowther, including without limitation. And then it goes on to discuss various types of damages. So there may be some dispute about whether a particular damage is consequential or direct, but there can't be any dispute about the fact that this provision clearly and unambiguously waives any claim to special or consequential damages. Thank you.
Thank you. Mr. Brennan, you recognize?
But before you start, Mr. Brannick, Mr. Webster said that a couple of things that I wanted to get your reaction to. One is that leaving the opening that allowed the rainwater in, what was a breach of the contract. Assuming that was a breach and that lighting the chimney on fire was a breach of contract, Mr. Webster also said that if the smoke and soot and water from the fire hoses from the fire and then presumably the mold from the water leak, if those things were direct damages, then they would not be excluded by the paragraph 8 exculpatory clause. If all that's true, in order for you to prevail, would we have to address anything other than just the definition of direct damages versus consequential? Would we even have to look at whether the exculpatory clause is enforceable? Who is the party to the contract? The independent tort doctrine? Would we have to look at any of that?
Yeah, well, the first thing you have to look at is whether this clause is enforceable, because if it's not enforceable, the limitation of consequential and incidental damages goes out the window. So you have to start with the enforceability of that clause, and it's not enforceable. Mr. Clausen testified that he tried to read it. He didn't testify that he read it and understood it. I don't think anybody has really understood this clause throughout the course of this case. But turning to the exculpatory clause, the only point that we're making is that you have to lay your cards on the table. You've got to make it exceedingly clear. And everything about the way they wrote the clause, the font size, is the opposite of laying your cards on the table. And looking at the Murphy case and the Fresnado case, those are cases where the court did look at different provisions in the contract and decided that they rendered the exculpatory clause ambiguous. The theme, though, that the important theme in those cases is that you can't set a standard and then disclaim any obligation to meet that standard. And they clearly did that here. And then there are interior ambiguities in that clause as well. And I think you, Judge Gannon, were pointing that out. We've got, first, they suggest, well, this is just a limitation of consequential and incidental damages. But that's not the position they've taken in the case. The position they've taken in the case is that other than the roof, they don't have to provide anything. The house could be burned down, and they don't have any liability at
Counsel,
all.
would you respond to his argument that the only direct damages would be the cost of the contract based on all of the case law?
All of their cases are product cases. So those are cases where you supply a product. In that context, if you supply a
Sorry,
product,
is that including the termite case?
well, the product in that case is the termite service.
Okay.
So they're all, so I would agree with Mr. Webster in that context. If you provide a product, the damage to the product itself is the direct damage, and any other damages, like let's say the roof did leak here, any other damages would be consequential damages. But that's not what happened here. We're not suing for a defective roof. We're not suing for a leaky roof. We are suing because when they were on the Clausen property, they flooded it. We're suing because when they were on the Clausen's property, they almost burned it down. That has nothing to do with the product. Look at the Tri-City Marine case that they cite. That was a case, it's the classic product case. A party installs a product on a boat, they install it improperly, and it leaks and causes damage. That's the kind of case that they're talking about. In those cases, yes, you are limited to the damages that you suffer. You're limited to getting the product the right way if they've properly limited their contract. But the workman on the Tri-City Marine case didn't sink the boat while he was on the boat. Clearly, if the worker commits some separate act of negligence while they're on the property, that has nothing to do with those product cases that they're citing. So, and I think that takes care of both the independent tort doctrine and the consequential damages issue.
No.
Anyway, for all those reasons, we think that the decision below should be reversed.
Thank you. Court is adjourned.